Those hearings are held, we hold those hearings, and I can only speak, of course, to our experience really in San Francisco. We hold those hearings at 12 different hospitals in the community. So we go to where the patients are. And at those hearings, the patients are represented and by the public defender, and we adjudicate the request. Then would come the temporary conservatorship if the matter advances to that level, and those are addressed as they come in, kind of every day of the week, and they're resolved on the papers, on the medical information submitted, and the petition submitted by the public conservator. Then the court conducts the hearings on petitions for a conservatorship, and also could be a hearing on medical powers, on medication powers, or a number of other related requests and petitions. So at those hearings, the public conservator, the city attorney, the district attorney, and the public defender, I should say before those hearings, all those parties collaborate to put together the cases and to assemble the calendar. Our clerk's office dedicates substantial resources to preparing the calendars, and then we hold the calendars. The organization of the calendars is several matters are submitted on the papers, and the papers being the petition and the medical testimony and the like, and those are addressed first. Then we hear the AOT matters and the CIPP matters. CIPP is another kind of outpatient program that we run in San Francisco. And then we hear the contested matters. So those are the ones with the evidentiary hearings, and there are typically a number of those. But the key to, I think, the way the LPS calendars are handled in San Francisco is the resources that are put into organizing them, the front-loaded resources and the resources put into them for hearing, and the cooperation of a lot of parties. And I mean, courts are, in the United States, in an adversarial process, but there is a lot of cooperation, and there's agreement where there can be agreement, and there's a lot of work that goes into that. We certainly appreciate and are very mindful, everyone involved in the system in San Francisco is mindful of the important liberty interests and the important societal interests, and we try to keep track of that on every case for every matter. It's also important to note that the courts are responsive. We respond to petitions. We respond to requests, and we resolve them largely on the rules provided by the legislature and on the evidence that is presented in court. So as far as kind of issues that we see, and I'll be brief and we'll talk about this more in the afternoon, but you've heard a lot about placement. Placement is an issue we see all the time. That's probably the most difficult portion of any LPS calendar. Transition treatments, and then legal issues about timelines that are built into the LPS Act, and how practical they are and how workable they are, appreciating that it's always a balance. Thank you.
Thank you. All right, so Scarlett Hughes?
No, I'm Tiffany Sen.
And just push the red button next to the microphone. That should turn it on. There you go. Okay.
Thank you very much. I'm Scarlett Hughes. I'm the Executive Director for the California State Association of Public Administrators, Public Guardians, and Public Conservators. Our members are the county official appointed to represent people who have severe mental illness. We're appointed the conservator, become responsible for all of their care, their decision-making, all of their property. And despite the various mandates put forward in state law, our members receive no state funding, no dedicated state funding. In fact, as near as we can tell, we are the only major health and human services program that receives no state funding. And as the only major California county social service safety net program which doesn't receive state funding, our programs are struggling to meet the demand. Our populations are growing by leaps and bounds, in part because of numerous laws that have been passed over the last, say, 20, 30 years since realignment. Our caseloads have more than doubled. We have about 50% of the staff that we need to meet the need currently. And so we submit respectfully the following suggestions. Or I should say, identify the following obstacles and difficulties that our members are facing. Our members are so short-staffed that we cannot provide the care that our clients deserve to the level that they deserve it. An ever-growing number of individuals with serious and persistent mental illness exiting the jails, the prisons, and acute hospitals has intensified, and we are getting those referrals because of the diversion from the prison system, from the juvenile justice system, from the justice system. Those individuals are coming to conservatorship. That has become the norm throughout the state. Justice reform has really resulted in conservatorship as the alternative to incarceration. And that is not, and I'm not saying that because that's the wrong thing, that's just the reality. And those individuals do deserve treatment and oftentimes need conservatorship. The problem is there's only so many staff in a given office, and we simply don't have the capacity to absorb those individuals any longer. In addition, the incompetent to stand trial crisis that we're seeing in our state is also impacting our members. These are individuals who have been charged with a crime, and they have been determined to be incompetent to stand trial. They don't have the capacity to participate in their own defense. So as a result, those individuals go for treatment to be restored. Oftentimes they're not restored, and so they come to conservatorship as a result. There's a law that goes into effect the 1st of January, which is going to double that number that we're getting now because of the misdemeanor incompetent to stand trial cases will all be coming our way. Not all of them, that's not accurate. But we will be seeing an increase in those cases because they no longer will be going for competency training. They will be coming mostly to conservatorship. The high burden of proof in the LPS Act and many case law precedents have narrowed the definition of grave disability. It has also led to the unrealistic expectation that public guardian conservators are the answer to the societal problems that we're challenged with at the moment. Mostly the homeless and unsheltered. There is a belief in some areas that conservatorship can solve that problem. I'm here to tell you it cannot. We do not have the capacity, nor do a lot of those individuals need that level of care. However, because of the crisis that we're seeing, there's an increase in looking to conservatorship to solve that problem. We also don't have any partnership with a state agency. Without a state partnership, we can't meet the growing needs or collect the data that we need to measure the quality of the services that we're providing, and certainly can't develop the information we need to guide future policy decision-making. Our public guardian and conservators are also taxed with the fact that there's no placements. You've heard that earlier, so I won't go over that again. And we also have a severe lack of psychiatrists at the county level to help with the indigent population, which is most of what our members serve. And with that, my time is over, and I'm ready for any questions if you have any.
Thank you. So we'll move to our last speaker of this panel, Tiffany Leon Sinnott.
Yes. Can you hear me?
Yes.
Thank you so much for the honor of being here today. I am a public defender. I've been a public defender for 20 years, and I've specialized in conservatorship for the last 15 years. Public defenders' offices have a unique lens because we're not only seeing individuals in the criminal justice system with mental health, but we also represent individuals at the psychiatric holds, and when they later go on to writ of habeas corpus for those appeals of those psychiatric holds, and then later on in LPS conservatorship. I'm going to start with some data. Over the last 9 months, our public defender's office created a pretrial support program where we go in and we interview people in custody prior to arraignment to figure out what their needs are. We do evidence-based tools to assess. One of those tools is the brief mental health screening tool. I can tell you in the last 9 months, we saw 1,217 individuals. Of those, 52% had mental health issues. 89% needed social worker follow-up support. 48% needed housing, and 44% had a substance use disorder that needed treatment. So our job is then to say, where do we put these individuals? Are they going to go to the collaborative courts? Are they going to go to diversion? Or do they go through a conservatorship track? We then are in the psychiatric facilities. We have 8 psychiatric facilities in Sacramento County. Of those 8, everybody that comes in on a 5150 hold have a right to a certification hearing with patients' rights. They then have a right to appeal that hearing. They can be held in a psychiatric facility on holds for 47 days before being put on a temporary conservatorship. How many people are we talking? Well, in 3 months at 8 psychiatric facilities, there was 1,963 holds. Of those holds, 1,590 ended up in hearings. The public defender's office took 300 appeals off of those 1,600 in hearings. And what we track is how many are from our county and how many are from other counties. Because Sacramento County is fortunate to have a lot of acute psychiatric facilities, we get a lot of counties bringing their clients to our county because they don't have those resources. So of those 1,900 people, 25% were not Sacramento County. In total right now, we have roughly 250 people on LPS conservatorship. That's down from 2008 when we had about 500. So let me tell you just through my lens where I see the 5 obstacles that we're really facing. Number 1, lack of placement in housing. We've heard that over and over again. Conservatees are usually placed in boarding care, locked placement, or through the state hospitals. Those are usually your 3 avenues. Boarding care, there is a licensing issue, and I'll tell you what it is. Room and boards don't require a state license. So guess what's happening? Those boarding cares are shutting down and being called room and boards. It's a whole lot easier. There's no oversight from the state, right? And they can charge what they want, and there's nobody auditing them. There's no one coming in. So we're seeing an increase in all these room and boards popping up everywhere. But we can't place people on conservatees in a room and board that's not licensed by the state. The other thing we're seeing is the state shut down our developmental delayed centers. And where did those individuals go? They went to boarding cares. And guess what? Boarding cares got more money for an individual with the developmental delay issue than with the mental health issue. So what you had is your boarding cares across the state become developmental delayed boarding cares, where those boarding cares made more money, leaving the mental health boarding cares shut down. Locked placements, we have long wait lists to get into acute facilities. Department of State Hospitals, we have that wait list. Right now, all this impacts the entire systems. I talked to UC Davis. In the last 2.5 years, they had 14 patients pending conservatorship holds. Those 14 patients made up 5,309 days. Money? Well, on an average $5,300 a day, that's $28 million for those 14 patients sitting in a UC Davis hospital when they could have been somewhere else. I have clients in jail waiting 2 years for LPS placement. We have an acute psychiatric facility that has 50 beds, but 47 of them are LPS conservatorships that can't move into better placement. That's not the appropriate place. Real quick, because I'm running out of time, lack of coordination with the system. We're trying to coordinate private sectors, hospitals, jails, mental health facilities. We have lack of coordination with states. We right now have states and counties not having resources, so they dump into other counties. And the other big issue is funding. We have great state funding. They're not allocating money just for LPS. They're one-time funding, and they're not carved out. This causes recycles of holes. This causes problems in placement. We have lobby discharge happening. We have increase in 1368 issues happening. We're not addressing needs up front. Thank you so much.
Thank you. Thank you. Interesting panel and